The English legal system is a common law system, and as such, judicial decision-making plays a significant role in the development and refinement of the law. So what are the origins of a mechanism so intricate and deeply enrooted in the English legal system? Prior to the Norman Conquest in 106, there was no unified legal system in England and Wales. Different regions had different practices which were influenced by local customs and conventions. Law enforcement was the responsibility of regional lords and sheriffs. There was no recognizable central government at this time. When William the Conqueror came to the throne, he sought to establish a single unified legal system and a centralized government. He achieved this unification by traveling throughout the country with his justices to hear disputes and administer justice. These traveling courts were called the Curia Regis. The king and his justices carefully selected laws and customs from different areas of the country and began to apply them consistently throughout the realm. In historical terms, this is the origin of the common law system, a legal system which is common as to the country as a whole. As the common law was gradually developed, it slowly became more and more rigid, until eventually its development stalled. The factors causing the rigidity were many. The early common law operated on the basis of restrictive form of stare decisis. The strict form of the precedent meant that judges were bound to follow decisions made in earlier cases. There were inadequate mechanisms available to avoid bad decisions, and as a consequence, the law became stale and inflexible. To add, the only available remedy at the time was damages, or in other words, monetary compensations. This was not always a suitable remedy. As a result of these defects and other inefficiencies in the common law system, many individuals were left without adequate means of redress. Individuals began to petition the king, requesting the resolution of their dispute. As the number of petitions increased, the king delegated the responsibility of hearing these disputes to the Lord Chancellor, who was free to determine individual cases on the basis of what seemed right without worrying about precedent. A body of distinct rules began to emerge from these courts, known as the rules of equity. The courts of equity also developed a number of innovative remedies, known as equitable remedies. These, in essence, supplemented those available at common law and included the likes of specific performance, injunctions, rectification, and rescission. The most important point to note in the relation to equitable remedies is that they are discretionary in nature. This can be contrasted with damages that are available as of right. A particular problem that arose as a result of development of equity was the operation of two bodies of law within one apparently unified system. The common law had one body of rules that were applied only in the common law courts. Equity, on the other hand, had an entirely different body of rules available only in the chancery courts. This situation inevitably led to conflict, which was eventually resolved in the Earl of Oxford's case. The case held that in the event of conflict between the two, equity would prevail. In circumstances where a claimant requested an equitable remedy, it was essential that they commence proceedings in the courts of equity. Common law courts were unable to administer equitable principles and remedies. Eventually, it was decided that there was no need for equitable principles and common law principles to operate in separate courts, nor was it necessary for the common law courts and the courts of equity to operate different procedures. As a result, the Judicature Acts of 1873 to 75 provided that equitable and common law principles and remedies would now operate in all courts. It is worth noting that the Judicature Acts did not fuse equity and the common law. In reality, it simply brought together the administration of equity and common law. The common law and equity, therefore, continues to exist as separate bodies of law.